to audits. This is a brand new revision that is a substantial revision that was just approved last week by Best Practices Committee. And the final approval was yesterday during the executive committee. So this is hot right off the press. And it's very exciting because it is very understandable for the lay person. Anyway, please, we ask that you keep on silent so that way it's disrupted. And it we're trying to go brief, so if you would, please complete the session evaluation on your phone. Or if you prefer, we do have the registration. We do have the session evaluations that you can complete as well. And we'll be passing the attendance. Please fill that out. And now we're ready for the Honorable Sharon Bock. She will introduce it.
Thank you, Cindy. First of all, I want to welcome all of you this morning and tell you that, of course, I'm Sharon Bock, and I'm the Clerk and Comptroller for Palm Beach County. Today, though, I am going to be Moderator, which is a very easy job, and the reason I say that is because our panelists are so incredibly experienced. We have the entire, the clerk's office in itself has tremendous experience in not only guardianship, but in courtroom experience and what we do every single day in the probate area. But I will tell you that this is really a brand new area in which we have plowed full steam ahead. And what we have for you today is a brain trust of how to get started in your guardianship program if you haven't done so yet, and really the exciting news about what the best practices are that we're all going to be sharing so that we have a uniform way in which we are doing our guardianship. You know, Florida today, because of the bill, Florida is now on the cutting edge, not only in the United States, but actually in the world, where monitoring of guardianships has come in. And I say that because Anthony and I have had the great opportunity of speaking all over the United States. And as a result of that, we actually know what other states are doing. Tennessee, Washington, not only Washington, D.C., but Washington State, Texas, etc. And they are looking to us. And I got to tell you, as we become more mature, as you create your guardianship program and we get more data, we are really going to be on the leading edge and continue to be on the leading edge in the entire United States. And in fact, bar associations will be calling us, as they have been, to ask us what we're doing here. So, the reform of elder law is really what is going on all over the United States. And industrialized nations have always looked at the exploitation or abuse of those that are considered the most vulnerable of our society. For us as clerks to be in the position of actually helping change society in the most important area that is really coming, then for us to not only be in this position, but to take advantage of these best practices, and what you'll hear today is nothing short of putting yourself in place of helping to stop really one of society's biggest ills, and that's the exploitation, financial exploitation of the elderly. The panel members today are probably known to all of you, and I'm going to be introducing them as they stand up. But just as an aside, we have Bock Melton, the Inspector General from Lake County, raise your hand, Bock. We have Anthony Palmieri, our internal auditor in Palm Beach County. We have Lita Hugh, a CPA and the Inspector General in Polk County. And we have Jean Sperbeck, the Counsel of Alachua County, which is right here. Our objectives today, do I have the thing? Oh, that's my fault. Sorry about that. Perfect. Our objectives today are to review the new and improved best practices, We're also going to go over what an audit is versus what an investigation is, because you will be doing both of those. We will talk about the guardianship how-to guide, and that is continuing to set up your office. And of course, we're going to hear also about setting up, or a little bit about this, how to set up an Inspector General's office. And then we're going to have a high-level audit tutorial. Because you took the survey, and thank you all for taking that survey, really appreciated it, you're going to see that much of the information that you're going to get is exactly what you asked for. This is informal. Please ask everyone questions. Feel free to raise your hand while they're speaking, but we will be giving 5 minutes after each speaker for you to ask specific questions. Write them down, but feel free to ask them while we're going. I'm going to now start with Mr. Bock Melton and to go over with us the approved best practices. Now, Bob has a master's in public administration, and he is also a certified internal auditor, a certified fraud examiner, a certified public accountant, and a certified inspector general, okay? And probably things that he won't even put on his resume because they're too long and everything. He has worked for governments really all over the United States. I consider him one of the premier auditors, and I will tell you, it's always a pleasure to speak to him and about any issue. And if he doesn't mind, I'll tell you that just call him if you need anything as well as us, but he's terrific at it. Bob has always created a strong oversight role, and so he's been very instrumental in these best practices that he's going to be speaking to us today. But I do want to tell you that Bob has another presentation exactly at this time. As a result of that, he's going to be walking out. So if any questions that you have of him after his 15-minute presentation, please ask him, because he won't be here for the very end. Thank you, and this is Bob Melton.
Okay, well, as Bock said, this is a very important area where we can help protect the most vulnerable citizens. Okay. So the first thing I would like for you to do is get this concept of ministerial out of your mind. Okay. We're not speaking from a legal standpoint, which I know you all hear over and over and over again. This is an area where you can really, really make a difference. And it is not just making sure the numbers add up. That's the concept you need to get into your mind. And this is largely the mentality with clerks in years past. There's always been the statutory requirement to do an audit, and there was an audit fee, but the word audit was never defined anywhere. So what typically happened all over the state was these so-called audits would be handled by probate clerks who really had no training, no audit training, and sometimes there was a checklist that was floating around, and they would use that. But under the old basic auditing techniques, the basic thing was make sure all the numbers add up, make sure the beginning balance equals the ending balance on the previous report or whatever the document is, and then just make sure that the I's are dotted and the T's are crossed. Well, that doesn't really accomplish what we really need to be doing is a check and balance in the clerk's office. And that's really what the legislature is intended, especially now with the new legislation. They want the clerks to be active in protecting the board's assets. And so we have to, in my mind, not from a legal standpoint, but from doing our job standpoint, we need to enhance our procedures to try to do our best at doing that. And so with that, there was a definition of the word audit for the first time as it related to guardianships. And the part I want to highlight is the term includes various practices such as verifications, reviews of papers and accounts, interviews, inspections, and investigations. Wow, what a change from the desk reviews that have been going on for years and years. Now again, this is they call it a permissive statute. We're not required to do anything beyond the basic audit. But this, I think, clearly establishes what the legislature's intent was in doing the audit. And along with the audit is new legal authority. It says that we may request to review records and documents that reasonably impact guardianship assets. And you may not know this, but we can even go back to previous annual accountings and request documents and so forth, because those could impact the current annual accountings. So I think it's clear that the legislature intends and hopes that we will be active in making sure that the assets of the wards are protected. And that's kind of what these best practices are intended to do, is to give you all guidelines as to how you can be more active in doing these things. And the one thing that I'm sure you all know that's really important in guardianships is one size does not fit all. Many of you, the smaller counties, you may just have probate clerks that are doing the audits. Whereas the bigger counties have Inspector General's office, that have professional auditors and investigators on staff. So somehow we've got to put this all together so that each one of us, no matter how big or how small we are, can do our job in protecting the board. And so I'll explain it as we go along as to how that we can do that. But don't think just because you're a small county that you cannot implement this stuff. Because we have given you, as part of this set, all the tools that you really need to do so. Whenever you go from the old, I like to call them desk review type things, to what I would call the enhanced audits, it's important to communicate with the parties. And I can give you a quick example. Back from Panelists County about 20 years ago there when we started this enhanced process, it just so happened we came across a guardian that was very popular, that she was doing bad things. And so we started questioning her and asking for all this stuff. And she went and talked to the other guardians and got them all very irate at what we were doing. And so the guardian finally asked me to come speak at the Guardianship Association meeting, which started at 6:30 in the evening, but they had a networking half hour at 6. Well, when they asked me to speak, they said, we had this networking half hour from 6 to 6:30, but you may not want to come to exactly 6:30. So that kind of gave me a flavor of the meeting. It was very hostile. But I talked with them about how to avoid an audit, and actually went through some of the things that we were saying, and they were horrified. And at the end of the meeting, the president of the association came up and actually hugged me in front of the group, and it totally turned the whole situation around when we started talking with them. So they're one very important group. Typically with the Guardianship Association, the attorneys, many of the attorneys that practice guardianship law will attend. So if you talk with them, you'll be speaking with them at the same time. Great. And the other party that you really, really need to speak with are the probate judges. Yeah, because when you start doing enhanced auditing, it's a totally different ballgame for them. I actually didn't realize this for a long time. But whenever we went in Lake County and met with the presiding judge and the probate judge, the presiding judge was very intrigued by this. And he said, we're used to dealing with probate clerks, but you are really expert advisors to us. And I said, yes, that's it. And so if you can get that role as an expert advisor where the court is looking to you for advice, then that's great. Because what we are in this capacity is an arm of the court. We are to advise the court. And the other thing in communication is, it's also a change in mindset many times for the probate judges, because sometimes they don't know. They don't know what needs to be done to really look after the board. And sometimes they'll go by a statute or whatever, and maybe the statute requires, like for example, something we had recently, the attorney to itemize all of the charges, of course. But we have one attorney that just flat rate, petition, 1 hour, 1 hour, 1 hour, 1 hour. And the judge looked at the total amount and said, well, that's reasonable. But the judge hadn't thought about, well, what about the precedent? This attorney told us this is the way he thought we wanted to do it, and he's told otherwise. If the judge allows that, then that proliferates to other attorneys. And then pretty soon you've got everybody that's not really being accountable. So it's a touchy situation, but you've really got to try and educate the judge on what really needs to be done to protect the board. As far as the types of audits, if you look at the best practices, you'll see a level 1, 2, and 3. And these largely came from Pinellas County, which is what we adopted there. It's a very formal process for large counties. Let me explain the levels, and I'll explain how you can combine those. Level 1 audits are basically our desk reviews. They're the basic level of auditing that every single one of you should be doing. And that involves basically making sure the numbers add up, checking beginning balances. If there's an income stream like Social Security, make sure all 12 months are appearing in the annual accounting. Those basic type processes. And it's very easy if you design it that way for probate clerks to do that. Level 2 audit goes a little bit more in depth. In a level 2 audit, you look at specific instances and you think, oh, I need to see a receipt for that. And so you would ask for a receipt or an invoice for that. Like you see, as I did one time, a $20,000 dental service to a dentist on there. We wanted to see a receipt. Turned out that one was fraudulent, fictitious. So you start delving into individual questionable items. That's as a level 2 audit. Also, it involves confirmations. If there's some income source, you can contact the source of the income and ask for confirmation that that's all that we received into the guardianship. So it's that type of thing. A level 3 audit, I kind of like to equate to, you hear about those comprehensive IRS audits. They don't have so much anymore. So they come into your place and they go through every single thing you have. Nothing's off limits. That's a level 3 audit where we would go into a guardian's office or maybe their house and say, we want to see every receipt, every invoice, back up for every deposit, a whole ball of wax for a whole year of annual accounting. That's a level 3 audit. And so that happens, by the way, very rarely. In Pinellas County, during 2013, it was 0.5% of their audits were level 3 audits. They just typically are not done that much. It's really there as kind of a deterrent factor, preventive control, to let the guardians know they may be subject to this. But in reality, probably would only do that if it's something suspicious that was going on. I want to speak with you a moment about trust, because trusts have been a huge area. It's a mechanism that's used to get assets outside of the guardianship, sometimes for that purpose. Most of the time, it's at least under the auspices of getting money saved and still have a ward qualify for Medicaid. In many cases, it's a Medicaid planning tool. But trust can be an area where there can be significant financial abuse going on. For example, most trusts will allow payment of guardian fees and attorney fees. And of course, typically, if those are outside the guardianship, the court nor we see any of those payments. So it would be very easy for a guardian or an attorney to be double dipping with the trust, and the same goes for other expenses. So here are the rules, and these are backed up by statutes. I'm not sure if all the courts are aware of these or not, so it's up to us to educate them. If the guardian is trustee of the trust, or if the guardian is de facto trustee, meaning in many trusts there'll be an independent trustee, but there'll be a provision in the trust saying the ward directs the trustee what to do. And in that case, if the guardian is the guardian of the ward, then that means the guardian can tell the trustee what to do, which means the guardian is really in control. So in that case, that is something that we can look at. And in that case, where the guardian is trustee, that would be part of the annual accounting. And then there's also situations where the trust might have been created before the guardianship, but maybe guardianship assets are going into the trust. And in that case, the judge would have approved those assets going in there. Then that means that we can look at the trust. It would not be a part of the annual accounting because the guardian is not a trustee. But we could look at the financial transactions if guardianship assets are going into it. And then the third situation, which from our perspective is not the greatest situation in the world, but if the trust was created before the guardianship, and if there's no guardianship assets going into the trust, we have no right to look at it. It's outside of anything that we can do. The same for the courts. But that's the law as it stands right now. One thing I wanted to mention we're doing in Lake County, and this is, in my view, a tremendous thing to do if you can do it. you know, we audit annual accounting, that's by statute. But on the annual accountings, there are transactions that have already been done, especially for guardian fees, attorney fees, gifts, sales of property, sales of cars, sales of real estate. By the time those come to the annual accounting, the transaction's been done. So yes, we can criticize it, but what are we really going to do about it? So the way that we've figured out to approach this is to look at the petitions as they're coming through. And actually, I mean, from a practical standpoint, we're doing our audit of that petition item at the time of the petition rather than the annual accounting, so that we don't have to even look at it on the annual accounting. But there, we can question the transactions before they come through like real estate. Is there a value of the property? In some cases, there's no value at all. In some cases, it's the property appraiser's value. And we all know that's not necessarily where they're the correct value. Then we can look it up. You know, we can look on Zillow, which is a great tool for looking at value, where we're trying to get them to do certified professional appraisals on all real estate. But we can have an impact before the transaction happens to make sure that it's proper and has proper documentation. And by the way, when we approached the court with this, they were excited because that gives them additional guidance before approving petitions. And so I think it's something that will go over favorably with your judges. So we really, really urge you to consider that. And that's it for me. Time for questions. Any questions? Yes. You know, that's something that we really do not get into. In our reviews, we start with the letters of guardianship, and then we do the inventory of problems, but we don't look into anything before that. One thing that we do when we do inventory is we do a search.
Repeat that question, please.
Yes, the question was, do we have any problem with power of attorneys that are in existence prior to the guardianship? And so, you know, we do an asset search. We try to find any bank accounts or something. Sometimes it's in the initial petitions and so forth. And we will look at it, if it's going to be inventory, then we will make note of it. But that's the only way that we can look at it.
I want to say that the probate rules have been recently or about to be amended to strengthen that language about powers of attorney in order to documents that may be in place at the time that the guardianship petition is filed.
Any other questions?
Bob, I have a question of you. You talk about communication, and I know a lot of those in the audience may not have, or maybe just at the beginning of starting their guardianship program. What did you find was the most effective communication tool when you began your discussions with the judiciary?
The first thing that we did, and I recommended, is to sit down with the chief judge and with the probate judges as a group and explain the new law to them. First of all, that's a great way to explain why we're now doing this. It's a brand new law. And in our case, they weren't familiar with it. Then you can explain to them what all is involved in this and how it will really help them to have an expert opinion as to whether something is good or whether it's not so good.
Did you ever get any pushback from the judiciary or any of our other justice partners when you began developing this program in Lake County?
Like you said, in Lake County.
Yeah.
Because in Lake County, the answer is no. You know, now I think the word is getting around a little bit, and it's not such a new concept. When we started in Panelists County many years ago, there was a lot of resistance. But now, Panelists County, as far as I know, is very excited about how the process works. You know, change is always difficult. And so the best thing you can do is just meet with the parties and explain to them, and that will make it go a whole lot smoother.
You know, in your presentation, Bob, you mentioned that sometimes you described your level 1 and your level 2 and your level 3 audits, and you described that sometimes that you would have to blend them together. Since we have a little more time, would you give some examples or talk about how that blending occurs or why that blending occurs?
I'm glad you asked that. And in fact, that's exactly what we do in Lake County. We don't classify them as level 1, 2, or 3. What we do, and this was done actually before I came to Lake County, is the guardians are required to give us copies of every check that's been issued. And so we review those. And so with every annual accounting, we review the checks that have been issued. And if we have a question about any particular transaction, we have a formal process that we call letter to attorney, and the guardian's copy, and we send that to them and ask for documentation. And we tell them, please provide in 15 days or else we'll schedule a show cause hearing. And by the way, the new law strengthens that provision and says now that not providing this information in bad faith can be cause for dismissal of the guardian. So all you really have to do as a small county is do the level 1 audit. And if you see something questionable, ask for backup. We don't always use the formal letter to attorney. Sometimes we'll just call the guardian by phone or call the attorney or email them is really popular these days. You know, but just ask for the documentation, that's all you have to do. You don't have to get real fancy and involved with all this stuff. And you can train actually with the package, we have questionnaires, checklists to go down through on all of this. And your probate clerks can actually take that checklist and they can develop a sense of what maybe isn't right or what's not, what should be required, like with a real estate transaction, that type of thing. We've got the guidance there for you, no matter how small you are. Yes, good.
How do you react if during the audit you find problems or things that need to be investigated further? Provide that information to the judge, and the judge signs, moves forward anyway, and doesn't give any credibility to what the court has had. What's the reaction of the clerk's office in those circumstances? How are you push?
Well, first of all, we try to work it out with. Did you want to say something? Oh, there's a good question. Okay. She asked us if we see something that we think is a problem and is serious, and the court seems to ignore it, what do we do about it? And so really what we do is, first of all, we try to take it as far as possible before going to the court. We'll interview the guardian, we'll interview the attorney if necessary, we've actually even interviewed the board, and we'll interview other people. And we'll get as much documentation as we can get, and then we put that all in a report and send it to the court. And then we'll have a recommendation in there as to what the court should do. And, you know, if it's criminal, if it's fraud, what we'll do is actually we go directly to the sheriff in our case. And if we just take it in when we start pursuing the criminal aspect of it. If it's not criminal, it goes to report to the court. We wouldn't hesitate to explain to the court if we need to sit down and meet with them. But we try to put everything in the written report so they'll have information. And in the end, though, you have to recognize the judge is the judge. You know, we're not the judge, so it's up to them. But we try to put all the facts in there and make it persuasive, but then they're why it's a problem and all of this stuff, and hopefully they'll reach the right decision.
Bob, thank you very, very much. And Bob has, let's give him a hand. And also Bob needs to run out right now, as they say. He's so popular, he has another meal to get on. So thank you very much. You know, one of the most important things that Bob said, that he started out with saying, is that even though it is a permissive statute, it is not required. The goal of our society, as I mentioned before, is to protect the ward. And who is in a better position than us to do that? Now, it does also mean that we are not ministerial, as Bob said. This is an area in which we literally step outside of our comfort zone because we are now advisors to the courts. And I want to mention just in that question about the judge, I don't know if you know this, but across the United States, not so much, we don't see it so much here in Florida, but across the United States, there are judges that are accused of being in collusion with the guardians. So one of the things that we have remained staunch about across the United States, and why our program is in Florida is the best in the entire country, is because we are independent of the courts. We are not part of court administration. We are elected, and we do not answer to the courts. That independence and objectivity is what makes our guardianship law and places us in the best position, that when an advocate comes in, an advocacy group comes in and says, you're in collusion, or everyone is in collusion, where is it on our part to be in collusion? What is our game? We have none. So as far as protection of the word goes, we stand in the clearest and largest shoes to protect the most vulnerable, the elderly in our country. I'd like now to introduce to you Anthony Palmieri. And Anthony is with me. Anthony has a JD, and he is also he's with our Division of Inspector General, and he specializes in fraud examination. I actually hired Anthony 4 years ago and to start our guardianship program, in which we got from Panelists County, as Bob had talked about it. And what we did was really developed it. And I will tell you that today, Anthony not only is a member and asked to be a member of organizations literally across the United States, including Representative Pasadomo's new guardianship legislation. You know that Representative Pasadomo is actually enhancing some of our statutes. And because we have the largest elderly population in the entire United States. But Anthony is considered and is an expert in this area. He speaks all over the United States, not only with me, but by himself. He's asked his opinion. We recently we're doing an article for the Wall Street Journal, and we're actually trying to ask the Wall Street Journal, because it is a financial issue, to take an editorial. We're trying to meet right now with the Wall Street Journal's editorial department to see if they would actually do an editorial on this issue to bring it into the economic sphere. Anthony will be talking about why it isn't a ministerial role, but why audits and investigations are important for all of us to know. Anthony?
Well, thank you very much, Clerk Bock, and first, thank you, Cindy, and the rest of the FCC staff for inviting us to be a part of this panel. It's a very exciting time to be, for the clerk's offices throughout Florida. How often do you get a chance to be on the cutting edge, to lead the nation in something? And that's exactly with the legislation that was enacted last year. That's exactly what's going on. The clerk's guardianship audit law was codified, and it's based on these very same best practices that we're talking about today. The law, Bob went over a lot of it. I'm going to develop a couple aspects a little bit more. But the law gives the clerks the ability to efficiently and effectively obtain documents from third parties and unwilling guardians. It also, the waiving of the criminal background check and the consumer credit report is now an exception rather than the norm in many of our circuits. And as Bob talked about, it gives us the ability to audit and investigate fees, the attorney fees, the guardianship fees, the trust fees. It also gives us the ability to audit and investigate the beginning initial inventory. So you can see I'm using that word, audit and investigate, quite a bit together. The tool that really completed the clerk's toolbox was the legislative clarification to the definition of audit in 744-102. And as Bob has already discussed, but we're getting, one of the frequently asked questions is, what is the difference between an audit in an investigation. So I'm going to try and explain, and this is really, it's more of a concept. The investigation of fraud consists of a multitude of steps necessary to resolve allegations of fraud. Now, you may interview witnesses, you may assemble the evidence, write reports, deal with law enforcement and our state attorney's offices. But the biggest line of distinction is that the investigation has a potential to deal with someone else's rights. So these investigations are conducted with adequate cause, reasonable cause or predication. It can't be just a fishing expedition. You don't do a random investigation. You can do a random audit, but you don't do random investigations. So one of the characteristics of the investigation of fraud is the necessity of the investigator to establish intent, the underlying motives, by placing together, we're placing together this jigsaw puzzle of seemingly legitimate activities, and we're putting them together to piece a picture of illegitimacy. In law school, we talk about crimes of intent, specific intent crimes, general intent crimes. We use the term mens rea, or guilty mind, to describe intent. And the Association of Certified Fraud Examiners, which I'm a member, uses this fraud triangle: opportunity, rationalization, and pressure to describe the factors involved when determining someone's intent. So an investigation differs from an audit in the fact that the investigator is trying to paint this whole picture. And while they're doing so, they're maintaining this reasonable cause to first launch the investigation and to continue the investigation. I'm going to show you a couple of examples. Bob talked about our level 1 audit process, and I'm going to show you a couple of examples of how a level 1 eventually turned into a level 2 investigation type case. So I've got to tell you, these are currently open investigations in Palm Beach County. They're not only open, but they're ongoing. So I've changed the names to protect the innocent just a little bit. So this is the guardianship of Dean Peterman. Dean is 21 years old, and he suffered a traumatic brain injury. He received over $600,000 from a negligent security lawsuit. The clerks auditors, we have 4 clerks auditors in 3 different locations. The clerks auditors flagged this accounting because of these 3-4 transactions. And they voted, it was $147,000 to Babel Construction Company. There were 4 disbursements. And they forwarded this to the clerk's Inspector General for further review. Now, the first thing that I thought was, wow, that's a bunch of money being spent without a court order. Next, I pulled up the board's home on our county's property appraiser website, and I looked at the value. So now I'm thinking, wow, $147,000 disbursement, no court order, and the fair market value of the house is $34,000. Honestly, at this point in my mind, I'm thinking that this guardian, who was the mother of the ward, that it's just a case that she grossly breached her fiduciary responsibilities to her ward, her son, in this. Why would you do $147,000 worth of Babel construction on a house that's only worth $34,000? I start developing this as a finding to include into an audit report to issue to the court. Now, before doing so, my curiosity sometimes gets the best of me. So I spent an afternoon in our county's building department I wanted to know exactly what the specifications of this $147,000 project were. So I pulled the building permit application, and lo and behold, another red flag was raised. The contractor declared the value of this demolition and construction of the CVS block renovation. Well, he declared it at $38,000. Again, just another red flag of the numbers all not coming together and making sense. So I called John Babel, he's the owner of Babel Construction, and he told me that the job wasn't $147,000, nor was it $38,000 that he put on the permit, but in fact the job was $52,500. I thought to myself, wow, here's another, yet another little red flag is going off. I literally have these going off in my head. So now, as I do for all the audits, I review the entire case file, and in particular, I look at the application for the Guardian. And the Guardian, again, the mother, Sandy Peterman, she goes down and she lists no for all, have you been charged with a felony, have you been charged with misrepresenting, type case, misdemeanors, stuff like that. And under penalty of perjury, she responded no to all these questions, which wasn't exactly the truth. She was actually arrested for keeping a public nuisance, larceny theft, and she had a couple of retail grand thefts. So, in my mind, again, the little flags are going off, more red flags. And there was a bunch of other red flags going on. So, another step that I perform on virtually every guardianship audit investigation is reviewing social media. And why, you may ask? The number of social media users is quite frankly staggering. 1 in 7 persons in the entire, on the entire earth have a social media account. And we're very familiar with the ones listed on this slide. But there's a bunch that even me, even as an investigator, I'm not even familiar with Dig and Ending, or there's a whole bunch of social media. It's just not Facebook. It's just not Twitter and Instagram and stuff like that. So I took a look at our, yes. Oh, that's a great question, and it's actually the next slide. There's some powerful tools out there that makes surfing through these social media sites very easy, very efficient. Very good. Okay, so this was the Facebook pictures from regarding our Ward's Facebook page. Okay, the Ward is pictured there in the middle with the I Keep One Gold T-shirt on. Yeah, this is the Word. Yeah. This is not fake. None of this is fake. Just the names are fake. This is the Facebook page. Now I do a lot of cooking, and I don't think that's oregano. I could be wrong. If you could look very carefully, this is the Word. But he has a gun tucked under his thing. So, it comes down to, another red flag was there. So, in our social media investigation toolbox, we use all these different tools. Now, I'm not going to have time to go through each one of these. I can spend an hour just talking about the tools in this toolbox. I will show you the one called EchoSec. EchoSec, you're able through a map, you're able to select a particular area and all the social media metadata, the GPS coordinates, the addresses, and pull up all the social media for a particular selected area that you select. Same select a lot. Okay, so that's exactly what I did on this slide. I painted the box, I selected the area right around the ward's house, and a whole bunch of social media accounts. And then you can just based on, just using this tool, EchoSec, you can scroll through all the social media accounts that they have. For this ward, it was just Facebook and YouTube, a couple of YouTube videos. Yeah, I think we're putting the slides, but
This presentation will be placed on, this will be placed on the Clerk internet, and you can also go on the mobile app.
so the more we looked, the more we found. And and this is going to be my illustration on how we came to into this. So in addition to Babel Construction, we found these two payments to Patricia Walter, for $2,700. Now from the trustee for this, I requested to cancel checks, and we determined, based on talking to the trustee and the checks, we determined that the Guardian had rented an apartment unit during the time of that $147,000 renovation, and they rented this apartment unit from Patricia Walter. The trustee also sent me the rental agreement for the rental unit. There was only one problem. Patricia Walter wasn't the owner of the rental unit. A gentleman by the name of Dan Morrison purchased the unit about 10 years ago. So I talked to Mr. Morrison. He met me at a local Wendy's restaurant. He was very hesitant in meeting me. But we talked for a long time, and he denied ever knowing who Patricia Walter was. He even signed this notarized affidavit, in effect saying that Patricia Walter is not my agent, she's not a landlord, she's not acting as my manager, she's not authorized to receive money on my behalf. He had no idea who Patricia Walter was. At the end of the affidavit, I asked Mr. Morrison to list the unit, the tenants in each of those units. And then unit number 2, I'm just going to draw to your attention. At the time that I'm talking to him, I had no idea who these people were. But I'll draw your attention to Naomi Lang. Well, I went to social media again for each of these tenants. And lo and behold, Naomi Lang had a Facebook friend by the name of Patricia Walter. So I started, there's something here. There's a connection here. Starting to fill in that whole profile, completing the picture on what's going on. So then I'm going through our official records. I'm going through our criminal court cases. I'm pulling up every piece of information that I can think of, and I find a series of arrest warrants and probable cause affidavits linking. And this one right here is for a shoplifting case, and linking Patricia Walter to Naomi Lang. Skip this next. I had another, in case I had time, which I don't. I had another example, but I wanted to jump into the proposed legislation on the table right now with this current legislative session. And the three proposals that I have online are really the ones that are that have the potential to affect clerks' offices. So I'm going to briefly talk about each one of those. The first one is Clerk Bock talked about this conspiracy between the judges. This perception that there's a conspiracy going on between the judges, the guardians, the attorneys. Everybody's in cahoots to steal the ward's money. That's the perception, at least. Well, the first proposal is the rotation. If the judge is going to appoint a professional guardian as the guardian, they should do so on a rotation basis. However, in the actual proposed language, there is room for judicial discretion if the judge feels like a guardian with specific training or experience is needed, so they can pick who they want to best fits the needs of the ward. For example, if the ward has complex medical issues, they can appoint a professional guardian who is also a registered nurse. Or say the ward is the business owner, so you wouldn't want to appoint a registered nurse, but you might want to appoint someone with a business background. The second proposal that may affect clerk's offices is the moving of the guardianship plan filing dates. The proposal is to move the filing dates exactly 3 months prior to the anniversary date. All this, the impact of the clerk's offices is your tailor system. You're going to have to go into your tailor system, in our case, Banner, and change the due dates, so you know when the plan was supposed to be filed. So it's going to require going in. I don't know if there's an IT solution to that, but it may require going in manually to each individual case and changing the due dates of the guardianship plan.
That's still a lot of
Yes, and that's a good point. Jean asked, can that be changed by court order? Absolutely. And the important thing to know on this is this only affects the physical, the plans that are filed on a physical basis, not a calendar year. I think most circuits are on a physical calendar. There may be one or two circuits that are on a annual calendar. And then the third, and this really impacts the internal auditors and inspector general offices, there is a very clear link between the civil guardianship case and criminal prosecution for elder exploitation. So there's going to be a clear link in 744, which is a civil statute, to the criminal prosecution statute. Yes?
Just mention with the link to criminal prosecution, you mentioned specifically elder abuse or elder exploitation. What about words who don't fall into the age category, since they're going to be linked to other criminal prosecution?
It's going to link to a lawful offense against vulnerable persons. So I think it's a vulnerable person. So all wards would be considered vulnerable. In addition, it's 60 and up. So that's where I got that. Really, as I get older, 60 is not really
Sorry to kick Anthony off, but we will also have time at the end. We need some time at the end to ask some questions as well. But I want to make sure, as the moderator, that you have the opportunity to hear from everybody. Okay, so if you can break down your questions of Anthony. I know I always have a lot from him. In our country, there is a presumption that as individuals we control our own destiny. But that presumption is a rebuttable presumption when a person demonstrates that they no longer have sound judgment to make decisions about their finances. Today, you might know, and I'm not sure that everybody really sees the scope of this, there is over $1 trillion of other people's money in the hands of guardians. And should you think that some of these people are poor, you might want to look at some of the larger counties or even in your own counties. In Palm Beach County, we have several guardians that have multi-million dollars. In fact, we have one that has over $100 million in it. And I will tell you, this money makes even the most honest people want to charge more than they should or to bill more than they should. And again, well, this is one of the reasons why we stand in such a wonderful position to help the most vulnerable citizens, whether they be disabled children or elderly, who are under and in the court's control. So now what we have for you, I'm happy to say, is Lita McHugh. Lita is the Inspector General for the Honorable Stacy Butterfield, Clerk of Polk County. We only have one Palm Beach. Lita is going to talk to you about Polk County and the implementation of the best practices and what they learned while they established their program. Lita joined Polk County in 2013 to lead Clint Butterfield's initiative to transform the existing audit department into an inspector general department. Lita has 13 years as a certified public accountant, and now she is a certified inspector general. But more importantly, I want to announce that Polk County expects to be awarded, Polk County Clerk's Office expects to be the third county in the state that is going to be awarded from the Commission for Florida Law Enforcement Accreditation their accredited inspector general. And they follow Pinellas County and Palm Beach County. And I will tell you, anybody that wants to go through this program, I highly recommend it. Right, Stacy? So let us now hear from Lita. Thank you.
Thank you, Clerk Bock. Let me just adjust the volume here. All right. We started our journey to begin enhanced audits of guardianships shortly after I came on April of 2013. And our journey started with a dialogue between Clerk Butterfield and Polk County's sole probate judge. He had in hand a $3.5 million guardianship, and he wanted to know what procedures are we doing? Did we think we were doing enough? We looked at what we were doing, we looked at the accounting, and we agreed that we could do more. Also, about the same time, we had a situation where a guardianship with not so much money in it. There's a daughter who was the guardian of her father, and when he passed away, he had exactly $0 in his bank account. And that was because she was going to the Seminole Hard Rock Casino, gambling away his money. So the judge asked us to look at that and get as much information about that as we could, and that was a case that was referred and prosecuted to the state attorney office. So that's just kind of to illustrate, this is an important job and it's not anything you can take lightly. So I recommend that you start your process with a dialogue. It's important to be proactive. Not only is it the clerk's statutory duty, but you can help perform an important public service by protecting our most vulnerable residents. And then the consequences of failure can be irreparable damage to the ward, something that they may never recover from. And beyond that, as you well know, guardianship failures make great headlines. The very credibility of your agency is at stake. So first steps, you want to meet with the key players. The clerk is in a pivotal role to get the confidence and cooperation of everyone, including the guardians, their attorneys, coordinate with the probate judges, and your own staff to get everyone on board. So you want to meet with the probate judges, the magistrates, if you have any, and just understand what their interpretation of some of the more shaky ground, let's say, in the statutes, and what their opinions on matters of law are, so you know how they want to proceed in your circuit. You want to make friends with clerk administration because they can be your best friend when you've got an uncooperative guardian. These are the people who can send a delinquency notice or set a hearing date to give the guardian's attention. Obviously, you want to keep the attorneys and guardians informed because some of them may have been practicing a long time and they want to know what's changing and why. Why is what we're doing not acceptable? You want to keep your staff on board because without them, you can't make it happen. So to begin with, you need to find one champion to lead the way. That person takes the lead and coordinates all the players and kind of sets the path. Whether that's internal audits, your inspector general, or someone in the probate department, or in Jean's case, the Clerks Counsel. You want to also identify key staff in the whole process, maybe in probate, that you will have to have their input or you will fail. So to get started, your basic planning steps, and I'll kind of rush through these a little bit, but you want to look first at what are you doing now? you may find that the practices have evolved over time that may not meet the mark. You want to make sure you reacquaint yourself with Florida statutes because they get very involved. There are a lot of rules. They can appear contradictory. They can be unclear. And it takes a long time to understand some of the difficult issues. Then finally, this committee of us, we've worked very hard on updating these best practices. We've made the checklists so they're very user-friendly forms. We've re-examined everything. So we think this new product that's going to be out on the website, on the SEC website, is going to be very helpful. You can customize them if you want to, but we put a lot of work into them. So take advantage of this tool. You want to start the dialogue with your judge and seek constant feedback and input, what they like, what they don't like, what they don't understand. Determine the level of what you can implement in your office. In Polk County, what we have evolved at is probate staff. We have 2 people there processing. We've got over 1,000 active guardianships, I believe. Those 2 people handle the level 1 audits. They communicate with my guardianship auditor and me on some of their stickier questions because my guardianship auditor is very well informed in some of the more difficult questions. So they communicate via a spreadsheet, and Palm County actually developed this, so we kind of took theirs, tweaked it a little bit, and that saves someone having to walk back across the street with piles of paperwork and stuff. They can look at the docket, the e-file, and share their issues and questions via spreadsheet. Then the more difficult cases, which we are called level 2s, are done by my guardianship auditor. And occasionally, we have done 1 level 3 audit in each of the 2 years we've been doing this. And we went out, we interviewed the board, we looked at the premises. The one we looked at was a mentally developed, I think 18-year-old. So they had purchased a lot of specialized equipment with the guardianship fund. So we're like, okay, show us this, the equipment for the showering and the exercise and a variety of equipment. So we made sure we could see it and say, yes, that looks like a reasonable purchase with the guardianship funds. You want to determine what your staffing needs are. Do you need to hire more people? Can you work with the people that you got? And how much training do they need? Do you have really good resources in-house? Do you need to have someone really take the time to educate themselves and let that person train everyone else? So Palm Beach County has got a number of tools, which I think many of the people in this room have attended a training session that you all did online. And if not, then contact Anthony. He can send you to the hyperlink to that. There's one particular document I really enjoy. It's 25 red flags. And it's a list of things that you might want your staff to look at in an audit. Unusual transactions such as gift cards, credit cards, vacations, large amounts of cash withdrawn from the funds. The ward may have no relatives or may be isolated from the family. So this is a really great little checklist and it can help staff kind of understand what is the path you're on, where are you headed. Then take these checklists and customize them for your own office. Develop a workflow. As I discussed, we kind of pass things off from probate with the level 1s to the audits that they think need more attention, they pass to us, and then how do we get it up to the clerk? Build in a supervisory review process or your quality may suffer, particularly when you get started. Determine how you're going to communicate with the court. In our case, some of the circuits file their entire checklist in the docket, and magistrates may review it, and then the magistrates prepare an order for the judge, and the judge is simply signing off on stuff that the magistrates have reviewed before it gets to that point. In our case, we have one probate judge, so we prepare a one-page summary memo. If we're recommending disapproval, we list what procedures do we do, why are we recommending disapproval, and we give that to the judge, and that lets the judge make a decision. Also, you need to establish how you're going to communicate with the guardians and their attorneys. What we do, we use an email, we prepare a list of here's all the documents I want to see, and then we call, we say, okay, how quickly, I'm going to be sending this to you, I'm sending it with a read receipt, you send me back that read receipt or I'm going to call you again. How quickly can we have this? 1 week? And they say no. So then you say, okay, 2 weeks, 3 weeks, you agree upon a date, and then you say, okay, if I have not received these documents by March 2nd, I'm gonna have to send a memo up to the court and recommend further action. And we follow up on that. And that's the biggest time saver for us because that's a big waste of time waiting for them to get back to you. So get started, set your time budget, say, here's how I'm gonna do this, here's my time frame. Start with a few audits, start with some key staff. And take questions and issues and concerns from your staff and resolve that before you do a full rollout. Get feedback from the judge as you go. Expect feedback from the attorney. But understand this is a new process. Some of them we have been in practice a long time. So work with them, keep the lines of communication open with them, and they will buy into the process. By and large, I have found that most of the professional guardians in Polk County really do have the worst interest in mind. It's the family guardians that we have more issues with. So as the guardians start to trust you and get involved in the process, they'll understand we're not trying to create work for them, we're not trying to cost the board money, we're trying to protect the board. So this is really crucial to get them to buy in. Train keep your remaining staff for full rollout. Remember, it's not the same as last year. This is a new mindset. In some respects, it's risk-based auditing as to when do you kick it up to audit? What documents should I ask? Am I being nitpicky asking to see this or not? So it's very much a judgmental process, and it can be hard for them to get comfortable with. Know that you will make mistakes, admit it, fix it, and move on. Seek continual improvement in the process. And remember, this is really important to avoid. This is a real person with real issues and their money. This is all they have left in their life. Keep improving your work processes. I think we started out with a proposed workflow and we've revised it about 3 times. It's great, Bob mentioned, speak with the professional guardian groups and have informal meetings. That's one of the first things that we did was we sat down with a couple of the attorneys that process a lot of guardianships and we answered their questions early on. You'll find that the judge can be your best resource in referring potential fraud to you, maybe something that you've missed or maybe something you haven't gotten to yet. Attorneys involved and you'll find that they have your confidence and they will help you with the process. Now, we've gotten a lot of assistance from Panelists County and Palm Beach County. I have some tools that I've developed in the process. If you want to email me or Google Polk County Clerk, my contact information is unfortunately very easy to get to because I get a lot of phone calls and I really don't want. But I'd be happy to provide tools that we've got. Palm Beach County's got some tools and we can make available to you. But we'd be happy to help anyone else. There's a lot of help out there and I'd be happy to be contacted. I'd like to leave Jean last time.
Questions?
I'm sorry.
How much interaction do you have with your family guardian, with other family members questioning the activities of family guardian?
Okay, so the question is how much contact we have with the family guardian?
Actually, the non-family guardian, but their family members, and there's infighting amongst everyone between the family guardian and the non-family guardian.
Okay, so infighting between the family guardian and other members. Absolutely, there can be a lot of conflict between them. We don't deal with the other family members. I had one case where there were literally 5 attorneys involved in the guardianship. The ward had an attorney, the son and the daughter had attorneys. We had a court monitor. It's very expensive for the board when there's a lot of that. So you just deal with the guardian and the guardian's attorney as possible.
What kind of procedures do you use for verifying inventory to make sure you got everything?
Well, to some extent, we need to look at, the question was, what kind of procedures do we use to verify that the inventory is complete? You can only do what you can do. Seriously, it's a matter of judgment, and I don't know that I've got a good answer for you.
one of the tools that we use in Palm Beach County is LexisNexis. Yeah. Tongue spot, but for the initial inventory, if there's property in the board's name in Ohio, you're not going to know about it unless you run a powerful tool like that to which is the world's largest buyer of public and private information, and they put it in a very user-friendly database. So that's one of the Yes.
Well, it's something that we do is obviously go on our property appraiser's website and search for any other properties with the word they have in their name. If we feel that we need to, we'll get confirmations with the bank, and a bank confirmation. You can say, tell me any and all bank accounts that may exist for the board or in the name of the guardian. So you can tailor your confirmations that way.
Yeah, so if a guardian wants to deal with the board, the easiest place to start at the beginning. Don't show it.
Exactly. There are frequently transactions that go on before the guardianship starts. So what we did in one case was we had a situation where a husband was stealing from his wife before the guardianship actually got set up. What happened was we requested as many bank statements he would actually give us, and we were able to easily show the judge that a bunch of money moved around before the case was even set up. So that the judge required that money to be taken back to the wife.
And social media is another great example of a tool that you can use for the initial inventory. I had a caregiver that on their Facebook page was posting flaunting pictures of their basic surgery, their Botox injections, and their breast augmentation. Pictures showing it off. And they used the words credit card just prior to the guardianship getting started.
Okay. Especially if there's nothing between family members, quite often there is petitions for them trying to be guardians. Petitions are complicated. So you look at petitions, the assets that listed on petitions might have some circumstances, see if they filed everything that's on the petition. Especially look at every one of the petitions, it's multiple petitions.
Okay, I'll remind that for the recordings. If there are multiple petitions to appoint a guardian, then you look at the assets that are listed on the petitions. Okay. All right, I think I have enough time for review.
Thank you so much, Leah. When we started this, just to give you an idea of where you are, and I think that what Leah was talking about as far as setting up a program is so important for you to hear. But you need to know how really important this is for society. One of the reasons that I began this mission 4 or 5 years ago is because in Palm Beach County we had a very, very high-profile case, one of those Palm Beach, rich people cases, where the where the husband and wife were getting a divorce. The husband was, one of these $100 million kind of guys, and he killed his wife because she wanted a divorce. He shot her and killed her. He then went to jail, and when he went to jail, he ultimately died of pancreatic cancer in jail when he was in his 60s. They left a 12-year-old son, and this 12-year-old son was put in the hands of a court-appointed guardian, a law firm in Palm Beach County. And I followed the case a little bit, mostly for the notoriety of it, but I didn't really see any connection with us until another law firm in Palm Beach County sued the law firm that was the guardian for the child. And when they sued, I got the court records and started reading all of this and realized that this law firm had diminished this young child who doesn't have any parents at this point, had diminished their holdings by over 50%. And this law firm has sued them because they were charging as much as $700 and $800 an hour for kinds of the work that they were doing. Now, I thought, okay, I'm following this because this is just interesting, and I thought, oh, the court is going to take care of this. Guess what the court held in that particular case? They dismissed it in summary judgment, saying that no one had standing against the guardian. That's when I went to Panelists County and said, you know what, this is a crime against humanity. And I will tell you, I can't emphasize enough to you, whether you are a very small county and there's only one guardian in your county, or 1 or 2 or 5 guardianship programs open, there is fraud going on because our laws are antiquated, and you will see that even when you begin investigating it, that this area is so ripe for fraud that you are the only one that stands between that ward and them not having a quality of life because they have zero money. Because you want to see how fast these guardians start shedding these guardianships, watch when they don't have any money. So you're really there. You know, next, we have an attorney on our panel, Sperbeck. Jean has been general counsel for Alachua County since 2005, and previously she was a judicial staff attorney for 11 years. She reviewed guardianship accountings, she determined sufficiency, and prepared orders for the courts if accountings were inadequate. She received her law degree from the University of Florida and was in private practice for 10 years before she came into the government. I'd like to now have her talk about what she knows as the guardianship from the legal side. Thank you, Jean.
Test this, can you all hear me? So first of all, I want to just expound on that a little bit. I rode the circuit as a staff attorney. I handled all of the probate and guardianship cases for all of the circuit, and that included Levy, Wilkers, Union, Baker, and Alachua County courts. As an advocate. And the other thing that I got to do for that entire time period is that I got to teach the guardian education classes. Yes?
We can't hear you.
You can't hear me.
No, ma'am. Sorry.
Is that better? Yeah? Better?
It's a little better.
I'll talk louder. How's that? So, I had the benefit of talking to a lot of guardians and a lot of guardians attorneys. And I actually was involved when Mr. Irving hired a CPA for a while, and the guardians attorneys were all anonymous about things like, respecting the guardian to make sure the income taxes were paid, income taxes were due. It's been a lot of, the whole experience was a lot of fun. The thing that I found was that guardians, even the honest ones, have a lot of difficulty understanding this concept of fiduciary duty. They have a higher standard of care than the ordinary person. And the other big problem is that relatives really have a lot of trouble understanding why they can't use the ward's money to take care of the ward and have to keep receipts and get court approval and prove that they spent the money on. They have a lot of difficulty with that. They don't understand the problem of commingling, and keeping receipts and good records is also a struggle, especially when you're dealing with an elder or an adult ward, and you have to take care of their day-to-day expenses. Now, for clerks, of course, the number one problem is you have to have an accounting or an audit. So we, a couple years ago, discovered that there were a few holes in our automatic ticker system, and we went through and we looked at every single case, even determining whether things were really open or really closed, and made sure not really following my suit, so I'll apologize for that. Yeah, here we go, even if not sued. So, being sued is important, and so you want to make sure you're catching the accountants in the first place so you can't opt them. Then, this has already been touched on, you don't want the clerk's office to be seen as being part of the problem, you want to be part of the solution. Now, my idea of being part of the solution is to help your courts try to prevent abuses in the first place. Auditing is good, but sometimes an audit doesn't make any difference. The money is already gone. And it does break my heart to see somebody who has used the money unwisely or illegally abused that, and the money's gone. They've spent the money and there isn't any payment back. And so, in probably around 2005, we discovered a copy of letters from Miami-Dade County and held its stance on it. Can't sell real property without a court order. Can't make disbursements without a court order. What a novel concept. And if you do the research, you see that even when an account is set up and it's supposed to be a restricted account, if it's not set up correctly, even if there's an order that says that the court cannot do that, the guardian can't do that, the letters of guardianship is the document that gives the guardian the authority to do what he or she can do. And banks rely on that. It doesn't say that they can't do something in those letters, then they can do it, and the bank can rely on it. So when we started doing, this is true for the entire circuit, is we started issuing restricted letters. And it says right in the letters, it's got a little, in the letters of guardianship or whatever it is, it's got a little caption that says restricted. And it says in there, they can't sell anything, they can't buy anything, and they can't spend any money without a court order. Yes?
Are you saying that banks are ignoring court's restrictions on?
No, I'm saying that there might be an order out there, but unless it's on the letters of guardianship, so you can sue the guardian doesn't have the money. You want the deep pocket. That's the whole point of a restricted account, is you got the deep pocket. You got the bank says we agree not to release the money unless we've got a court order that says we can release it. But if that's not in the letters, and your guardian takes those letters and goes to the bank, they can open an account, put that money in the account, and the bank is off the hook. And I know 2 cases out there where the bank was sued and the bank was found not to be liable. So, right, so in cases where there's a lot of money and it has to be daily expenses, we have another novel concept in the circuit, which is a budget. So you can't spend any money without a court order, but if you need to have monthly expenses paid, then you have to get approval for a budget. That does 2 things. Number one, lets the guardian know that the court knows what they're spending. It gives the guardian some framework of what's reasonable, but it also lets the court know, and if you have auditors involved, auditors know in advance this is what to expect. So that there is no question down the road. Now, of course, you can say, you can spend $3,000 a month, and it's supposed to be in these categories, and then you still spend $3,000 a month on something else. But at least you've got some framework and some protections, so that the money can't all be dissipated in, a year or a month or whatever. They can only get at least that much a month. So the other thing is that I don't know that all courts know what a restricted account is and what's needed, which is you need an order that designates the depository in the petition, obviously. The financial institution has to actually agree to be a depository because they are, they are agreeing to become liable if money somehow goes out the door. And then you get the order, but then you have to have that receipt where that depository, that institution has said they received that amount of money. If you don't have that, then you don't have a restricted account because they have not put themselves on the hook for that dollar amount of money. And banks do what they do. We have banks that did set that up and they gave a debit card to the guardian, which of course they can't have a debit card because they can't spend any money. But at least you can get the money back from the bank because the bank is liable. So at least that ward is going to get that money back. In Alachua County in particular, we've been requiring all documentation on all cases. So I feel really grateful not having to start from square one. And what we have been doing in the past is simply reporting the lack of documentation that was in our audit. We have, the 8th Circuit has very active staff attorneys. My job, when I was there. And there was a period of time when the court's budgets were low and people had left and they didn't hire them. And we were finding that the courts were just signing off and everything, the usual complaint for everything's heard. And, but we find that happens sometimes anyway. And we don't really know, we haven't had a conversation with the judge, like, why did you enter this order when you said you shouldn't enter that order? And so we have started, based on the new legislation, sending letters saying we need this documentation, putting that in the court file so that if anybody were to look at the file, they would see that we made this request, which is why I'm not going to audit. That's another thing that's taken into consideration. We have this deadline for getting the audit done. And so we want to have something in the file explaining why that audit is not done. And we've had very positive response from the government. Anybody complaining, why are you asking me for this? We've also been examining the disbursements a little more carefully, getting all the receipts for things like checks, payments to Walmart, they should pay to Walmart or whatever, and just getting the documentation, what have they spent this money on. Okay, so we also, when I was a staff attorney, I know some counties are doing this and some counties are not doing this. On simplified counties, a guardian's idea of a year-end statement is the last statement of the month, but that is not a year-end statement. The year-end statement is a term of an accounting term of art that means all the transactions for that year. And so that means you need all the monthly statements, because that's not a year-end statement, that was a month-end statement. So you need that, and then obviously they'll qualify for simplified accounting unless it's had no disbursements other than bank charges and no income other than interest. So there can't be any attorney's fees on that. If it is attorney's fees, then it needs to be a regular accounting. I talked about this. So what I want to leave you with is, an ounce of prevention is worth a pound of cure. And if we are really going to protect the assets, catching them is great, but we don't want the money to be there for the board, is to work on some advanced measures to prevent the money from leaving in the first place. The other big recommendation that I have, and really this has to be a legislative thing, but I've had Guardian over and over tell me, I wish I would have known now, I wish I would have known then what I know now. Number one, they would have been a Guardian in the first place, but number two, they would know in advance what they have to do. So, it used to be you didn't have to take Guardian education until a year into being a Guardian, which got there because it happened between then and then. Now it's 4 months, that's still 2 months after the inventory is due. And I think there needs to be some preliminary educational, even if it's just an hour or 2 hours, something short, that you have to do before you become a Guardian. Because they really just do not understand. And that could even include, the clerk is going to audit, and, probably there will be some proceeding taking place. So that people who are interested in stealing money will be either dissuaded or will choose not to file a petition in the first place. And the last thing is, really look at this budget, restricted letters, restricted accounts, ways of really providing some sound protection for the vulnerable citizens in our counties. That's all I have.
proposal that has been made to the legislator is improving the quality of the guardianship education training, but it hasn't changed, the proposal didn't change the date. It's still within the 4 months.
Well, you know, part of the problem, as you know, that we have all found out, it is the family guardians that are creating a lot of the problems. And when you begin really doing a deep dive into guardianships, what you find is that a lot of the times the court has been very reluctant to step into the family's situation, just as they were reluctant years ago with domestic violence and with abuse of children. And as we become more and more outspoken as clerk's offices, as we present more and more evidence of the abuse, the kind that Jean is even describing right here, where the quality of life diminishes greatly because people's entire life savings is gone through fraud and theft. You're going to see that this presumption that the family can take care of somebody is going to be quickly diminished. It's going to take quite a few years, but I can tell you right now, in the United States, there is a lot of discussion about this, and there is an awareness that is growing on literally a worldwide basis. We only have a few more minutes left, but again, I want to thank Bob Melton from our panel, Anthony Palmieri. I want to thank Lita McHugh, and also Jean for the wonderful, wonderful job that they've done today. Let's give them a hand. And we may have time for maybe one question, one or two questions from the audience. Yes, sir. Yes.
I guess I want to respectfully disagree because we're finding some professional lawyers, and especially those that set up side companies that are being doled out services left and right, when it's already mentioned, but the board may not need those services. So if I have a case management company and another company here and there, and that board is being billed each and every month thousands of dollars, that can deplete their assets very quickly too, and that may not be for the benefit of the board, it may be for the benefit of the guardians, companies, and affiliates.
Well, there's no, he brings up, did everyone hear that? Well, there is a situation that is going on right now with professional guardians. And what I would say to you is join your local guardianship associations. I will tell you, that's the kind of information that Anthony brings literally every day to our Guardianship Association. He now is on board of directors of our local Guardianship Association.
For the state?
Of the state board. And I will tell you, that is where you can get involved. And you are exactly right. We constantly uncover the guardian's wife is a realtor, the brother-in-law owns a lawn mowing company, and suddenly, you know, when the house needs to be sold, it's that realtor, and every single month the lawn mowing company is the lawn mowing company of brother. But all of that comes in with your investigations. And you can investigate that, and you can bring that to light. But I will tell you, we have found that by far, and Anthony can speak to this as well, that the guardianship associations have been sick, they're sick and tired of being bashed, seriously. And as a result of that, they encourage us to be able to come in and tell them who are the wrongdoers of their own kind. Another thing that we didn't touch on was the hotline, okay? And right now, I think we have 3 hotlines, so 3 of us that are the certified inspector generals have a hotline. They are cheap, they are easy, they are confidential. We have an answering machine. Anthony is our hotline, frankly. We don't even use any kind of big system. And we have a telephone number that we publish. You guys already have telephone numbers. But what we do is we publish it on on all of our documents and in all of our all the information. And I know Ken and Bob for Lake County and Stacy and Polk County, and I know for us. I will tell you, we get a lot of people using that hotline for anonymous tips, particularly about families and particularly about these hard to find connections between people, you know? And so that we would seriously encourage you to do that. And today, if there is a takeaway from all of us, it is, and I think that, again, Jean said it best, we have an opportunity to do something. Why would we allow our office to lose credibility by not having this program in place in all 67 of our counties? I highly encourage you to do it, those of you who haven't yet or just are sitting on the fence thinking about it. I also want to say that I believe we have the Brevard, a few state's attorneys from Brevard in the audience. Would you raise your hand? The state's attorney from Brevard? Yes. I wanted to ask you, would you mind standing up? I don't need to point you out. But
I'm an assistant state attorney. Not the state attorney.
No, that's okay, assistant state attorney. We thank you very, very much for being here. This just goes to show you how important our judicial partners are. And I just wanted to ask you real quickly, what is the evidence? What evidence is the most helpful for you? Could you tell all of us who are auditors in the room that as the assistant state attorney, I take it you know this area, practice in this elder law area. What would be helpful if you could talk to the crowd?
Absolutely, and I do all of our elder and economic crimes specifically. So I would say spreadsheets are huge for us. There is a rule of evidence that allows attorneys to admit summary evidence for your jury who's not going to understand complex bank records that span many years. If you can do nice charts, graphics, summaries, things that would help a lay jury to understand the financial transactions, those to me have been the most helpful because you can explain what's happening to assets very quickly with nice diagrams and spreadsheets, and for the attorney it helps us to really wrap our head around what is actually happening. So for the people who actually do the audits and the accountings, that I think is the most helpful thing to us to understand, you know, why a transaction is suspect. I think Anthony did a really good job of showing those visuals. You know, you maybe don't understand the story of what's happening to that individual until you start seeing the images of the house and, you know, some of those visual pictures of what's actually happening are so powerful. So that, to me, is most helpful.
Thank you so much, and I find it so interesting that I know our state attorney in Palm Beach County has developed a very broad elder law practice in his area, and it's wonderful to see that Brevard, and I know many of you probably have that. And it would, again, in discussing this, communicating this, go and talk to your state attorney, go and talk to those who know the elder law attorneys. Also, I believe you just passed around a survey or a, do you want to?
Yes.
Yes.
We still have some CPs available for you. And we do have the session evaluation forms, so please, if you do not use the evaluation on the phone, please take one of these to the evaluation. And if for some reason you misplace the names of the representatives, or if you have further questions, you can always call me. If I do not have the answer, I was definitely be able to help. So please call us.
Thank you very much, and also please know that every one of our panelists are open to any phone calls. We also do trips to your offices to help you in any way that we can. Thank you so much for your interest in this very, very important area. Thank you.